Good afternoon, everyone, and thank you for joining us today. We are going to be presenting a fraud seminar for all of you. So I'm Zoe Thompson. I'm Head of Insurance Fraud here at 9 St. John Street. And today I'm going to be joined by three of my colleagues. So we have Jamie Hill. Give us a wave, Jamie. Beth Corns. There's Beth and Leanne Jones. So we've chosen three topics today, which we hope are going to be informative and which we consider to be trendy topics in the fraud arena. We're going to start with Jamie and I presenting a joint seminar in relation to fraud rings. And after that, we're going to have Beth Corns talking about case law, giving you an update on case law in relation to fundamental dishonesty. And to finish it all off at the end of the day, Leanne Jones is going to keep you entertained with how social media evidence has been used successfully and unsuccessfully in defending fraudulent claims. So let's start with fraud rings. I'm just going to ask Jamie to screen share understanding fraud rings. That's the topic. And just a quick introduction where I tell you what Jamie and I are going to run through in the next half an hour or so. So we're going to look at some definitions, what a fraud ring is, how you identify a fraud ring, how you defend a fraud ring, and how you present a fraud ring. Then we're going to move on to some of the hotter topics, so tort of deceit, exemplary damages, contempt of court. We're looking at them in the context of fraud rings, but those will be areas that are familiar to you throughout fraud litigation. Then we're going to be looking at non-party cost orders and some of the big cases that have been decided this year in relation to that in respect of credit hire companies, and then moving on to current trends. So what is a fraud ring? Well, you're not going to find a definition in a textbook or in a case, but this is how I define a fraud ring. I'm always looking for an organized group of people. So all that really means is it's the same people or organizations that you think are perpetrating the fraud. The second thing you're going to look for is a defined modus operandi. And in the next slide, I'm going to explain what exactly that means. You are normally looking for a particular defendant or an industry that is being targeted. So a particular defendant, for example, in the Tesco litigation, or a particular industry, for example, a few years ago when the travel industry was being targeted by fraudsters in relation to sickness claims. And you are always looking for a combination of some sort of dishonesty or fabrication or some sort of exaggeration. The modus operandi. So this is at the heart of every fraud ring. It's crucial to identify what your MO is. So at the outset, you want to be able to recognize how your fraud ring operates. You want to be able to list what your striking similarities are, and you want to understand what the rationale is lying behind the MO. So I always describe this as telling the story to the court. For example, you want to explain that these are individuals who are going around inducing rear-end accidents. And the reason they're doing that is because liability is likely to rest with the defendant insured's driver. That they're doing it in cars that have already sustained significant damage to the rear. And they're doing it that way because then it opens a gateway to a personal injury claim as well as substantial hire claims. So this is the persuasive part of every case and is at the heart of every fraud ring. Next slide, please, Jamie. Your dramatis personae, or some people refer to it as your key protagonist. So the purpose of a fraud ring is always to make money. And so when you're looking at who your key protagonists are, you want to look at who benefits from the fraud. And you normally have a leader or a group of leaders, and you have facilitators. And I always think of the key protagonists in a fraud ring as forming a bit of a pyramid, where you start with the people who are there actually, for example, staging the accidents, then you move up to the repair garage, then maybe the credit hire company, And at the top of that pyramid, you often think of it as being the claimant's solicitors. And what you often find with your key protagonists is that each layer becomes harder and harder to prove any involvement and to get beyond that grassroots level, if I can put it that way, of the actual people perpetrating the fraud on the ground in terms of them being the claimants, and the next layer up, which is usually your repairing garage. Do you want to move on, please? Next slide. How do you identify a fraud ring? Well, it all starts with your intelligence gathering and the analysis of claims and data that you have coming in, spotting similarities, spotting unusual patterns, spotting things that are happening repeatedly in cases. And what you can sometimes find when you start with your fraud ring is that you have a lot of cases that might fall into a very generic category. So you have the same solicitors, the same credit hire company, you might have the same geographical area. And the more you delve down into the detail, you're able to identify clusters within that ring. And you end up with a much smaller identifiable fraud ring within your bigger overall ring. And you are looking at claims which include the same groups of people or organizations. That's normally how a fraud ring starts. And then you delve down through your intelligence analysts to uncover a much smaller cluster. How do you gather the evidence? Well, the first thing you do is you have a team of people who understand what it is you are looking for. So that includes the solicitors, obviously, the same solicitors dealing with the cases, instructing the same counsel who will go along to the trial and who will understand what information it is they need to unravel. Obviously, the same intelligence analysts. And if you're dealing with a case with experts, you normally want your own medical expert looking across all of the medical reports and your own engineer looking across all the engineering evidence. Then you have the usual, your residential and company's house data, social media inquiries, which is often where you find the link between individuals, and your lay evidence from your policyholders. Surveillance is becoming much more commonplace in fraud ring litigation. And what I'm talking about there is a lot of the time claimants being put under surveillance to see if they're actually hiring a vehicle, if it's a long period of hire, and or the grassroots level fraudsters, in other words, the garages, the repair garages, the storing and recovery people being put under surveillance to see exactly what kind of business it is that they are operating. Next slide, how you present a fraud ring. So normally a fraud ring starts with a very generic defense that you want to have prepared. This is if you're going to be pleading it as part of a fraud ring, which I'll come on to in a moment when we talk about the difference between offensive and defensive fraud rings. You also want to have a schedule of cases. So your schedule of cases will record each accident, usually in chronological order, who the claimant is, what the type of accident is. So for example, an induced accident at a roundabout, where the location is, the repairing garage, who the credit hire company are, who the solicitors are. And so what it means is that when you're looking at your schedule of cases, you can see in a very graphic form the similarities that run between the cases in your ring. And you are also explaining the modus operandi. You are explaining who the key protagonists are and what their role is in the ring. And you are also looking in terms of your individual cases at any particular fraud, for example, a fraudulent personal injury claim in relation to that particular case. One particular point to pick up on here, which I'll come back to in the next slide, is that what you often find with fraud rings is that the best cases you have are not the ones that the claimants are presenting. So they're the cases which either get discontinued or never litigate in the first place. And what is unique about fraud ring litigation is the fact that you can still use those what I call dead cases to present your fraud ring before the court. Tactics. So let's talk briefly about the difference between offensive and defensive tactics. So if you are running a fraud ring defensively, what that means is that you are effectively running each case on a standalone basis. So you might know that the case fits in to the modus operandi of the fraud ring that you have, but you're running it as a standalone trial. You are doing that perhaps for cost reasons, perhaps because it's too early on in terms of the fraud ring investigation, but you are running it as a standalone case. And what you might find with running a fraud ring on a defensive basis is that you are winning a good proportion of them. You might find you win 50% of your cases because the claimants don't turn up, or because when they do turn up, they go off script, or because you have some sort of unexpected concession that's made in cross-examination that gives you a good argument. But there normally comes a point in most fraud rings where you stop acting defensively and you start acting offensively. And that might be because you're looking at your win-loss statistics and deciding you're losing too many cases at trial. And it might be because your insurer client just wants to see the end of the ring. And the best way to bring a fraud ring down is to expose it. And it's at that stage that you look at offensive tactics. Offensive tactics, which Jamie's going to discuss now, are about the insurer taking control of the litigation. So you're either not a defendant anymore, you're the claimant, or you're bringing a Part 20 counterclaim, and you are exposing the ring in your pleadings, and you are relying upon all of the cases, including the dead cases that the claimants never wanted to have run. And you are doing that because you want to deter, you want to bring an end to the fraud, or you're not winning enough cases just by fighting them on a standalone basis. And that's at the point where you go offensive and you start doing things like tort of deceit. So I'm going to hand over to Jamie now, who's going to talk about some of these offensive tactics.
Thank you very much, Zoe. All right, tort of deceit. This is when you as the would-be defendant put yourself in the driving seat and bring your own claim against the otherwise would-be claimant. So it's role reversal. You are now the claimant in an action, and the claimant or whoever's involved in the fraud ring becomes the defendants to the action. Tort of deceit is its own standalone tort. It's its own standalone claim. It can be brought by a claim form in the usual way, or by way of a Part 20 claim or a counter claim. Why would you use tort of deceit? Well, you'd use tort of deceit to recover losses or expenses that have been incurred in having to defend or meet a fraudulent claim as part of a fraud ring or otherwise. On the screen now are the key principles that need to be established for there to be a successful claim. I'll run through them very briefly, but you can see them on the screen. Firstly, there are representations made that were false. It was intended that those representations would be relied upon. They were relied upon, and in reliance upon them, the defendant or would-be claimant has suffered a loss as a result. So, i.e., in this case, someone says that they had a road traffic accident when they didn't. That's untrue. They know it's untrue. They intend for the insurer to rely upon it. The insurer does rely upon it, settles a claim, and then discovers what's happened. That is the kind of circumstance where a tort of deceit claim can be very useful indeed. Some further points on the tort of deceit. All tortfeasors are jointly and severally liable. So that is a very important thing to be aware of. when considering bringing a claim such as this, particularly when there are multiple people. And as Zoe's already mentioned, often there are a number of parties. And if we can establish that a number of parties have been engaged in the tort of deceit and are liable, then as long as one of them has the means to satisfy the entirety of the judgment, then that is going to be a very powerful thing indeed. The losses have to be quantified and proved in the usual way. It's not only about recouping the payments, and the example I just gave, you've paid out, but a claim can also include associated litigation costs, investigation costs, staff costs at the insurance company, and disbursements. So, for example, engineers' reports, so on and so forth. As well as compensatory damages, what can also be claimed is exemplary damages. And there are examples of that where significant amounts have been awarded in the region of £10,000 or more. So again, it's worth having in mind. And if you are bringing a tort of deceit claim, there's probably little harm in claiming exemplary damages as well. The defendant has the burden of proof. The standard proof is on the balance of probabilities. Again, that is standard. And when I say the defendant's insurer, of course, they are the claimant. Such claims can be expensive, and therefore it's important to ensure that there are favourable prospects of success, and that such an action is only brought where there are there's a good chance of it succeeding. Exemplary damage, that I mentioned that now, a little bit more information. On the slide here, we've got some of the key cases. So it's applicable where the conduct has been calculated to make a profit that may exceed the compensation that is otherwise payable. I said in excess of £10,000. We've got examples here on the screen of two cases. The AXA insurance case, £20,000 exemplary damages, and in the Tesco stores litigation that Zoe mentioned a few moments ago, £18,000 exemplary damages. So an award in excess of £10,000 is something that we do see, and there are examples of such sums being awarded. The next tactic that can be used for offensive approach to a fraud ring is contempt of court. Now, contempt of court has always been available, but its use in fraud ring or dishonest personal injury litigation has increased following the well-known cases of South Wales and Summers. Contempt of court is a mechanism through which someone is punished for their contempt of court. So you bring the contemner's behaviour to the court's attention, and the court then essentially punishes them for it. Again, the defendant has the burden of proof, but the standard of proof here is beyond reasonable doubt. So it's to the criminal standard, not the civil standard. Contempt of court is dealt with by CPR 81, and that contains a detailed and quite comprehensive procedural framework for bringing contempt of court proceedings. They're either brought by way of a Part 8 claim, if proceedings aren't already in existence, or if they are, by way of a Part 23 application. And in many cases, permission is required to bring the application. So much the same way as with an appeal, you can't just bring the application, you have to actually have permission in advance. And on the screen there are where permission is required. So how would one make an application? Well, really, again, similar to an appeal, it's all in the grounds that you have. So you need to set out the grounds of contempt, and they need to be clear, specified, and supported by evidence given in an affidavit or affirmation. It says on the screen, absolute clarity is needed for those particulars. Again, this is to the criminal standard, so it needs to be crystal clear to both the judge and the alleged contemnor exactly what you're saying they have done. It's important to note that an application often has requirements for personal service of the application and for orders to have penal notices on them. Again, this is all set out in Part 81, but these are what can appear small points, but can come back to bite somebody quite severely if they haven't complied with all of the requirements of them. So, as I said before, Part 81, it's important that that is followed in full. Do not delay with bringing an application. I'm aware of cases where delay has been fatal. There may have been, let's say, a finding of fundamental dishonesty, and then nothing has happened for 2 years, and then all of a sudden somebody wakes up and thinks, oh, there's grounds here for contempt of court. Now that can be fatal. It's not necessarily, but it can be, and it will certainly harm your prospects of success. So if you think I want to bring contempt of court proceedings, take some advice and get on with it sooner rather than later. Particularly given what the burden of proof and the standard of proof, there's got to be enough to demonstrate a good prima facie case, and there needs to be something within the application to demonstrate why it's in the public interest for the alleged contemner to be committed for contempt of court. Now dealing with some considerations when thinking about bringing applications for contempt of court. Firstly, warn the alleged contemner prior to making the application. That is an important part of these applications. I've mentioned about it being the criminal standard of proof. A defendant insurer in these types of cases is effectively taking on the role of a prosecutor in a criminal case, and therefore the way the application is approached and the way it's presented in court has to be and seen to be absolutely fair. So anything that makes it look like you're trying to slip something past the judge or take a shortcut is going to just backfire spectacularly. So bear that in mind. Also bear in mind, because of this quasi-criminal nature, the alleged contemner is entitled to legal representation and is entitled to have that legal representation funded via legal aid. If we think about what normally happens in, let's say, a personal injury case where there's been a finding of fundamental dishonesty, the claimant's solicitors, who are personal injury solicitors anyway, will have probably come off record as acting for them. So the claimant will be unrepresented. And if you want to bring a contempt of court application, it's important that you give them the warning, as I say at the first bullet point, and tell them they're entitled to legal aid and encourage them to take up that legal aid. I had a case recently that was listed for sentencing and it was adjourned because the alleged contemner turned up and said he didn't know he was entitled to legal aid and he wanted to go and get that legal aid. And we couldn't show that we'd written to him and said, you were entitled to legal aid. This is all the processes or procedures that you need to go through. Here's information from the Law Society, so on and so forth. Bear in mind the contemner has the right to silence and the privilege against self-incrimination. They don't have to give evidence, but they can give evidence if they wish to, and they can call oral evidence if they wish to as well. And in contempt proceedings, it's important to be aware they have the right to do so at any stage. So it's not like a civil case where if you don't provide your witness statement, that's it, you can't give oral evidence. They can turn up and give oral evidence and say what they want to without any prior warning to you. So you just have to be aware of that risk and be alive to it and bear it in mind when undertaking an assessment of the risks in a case. In terms of sentencing, the maximum is currently 2 years. And it looks as though that is going to stay the same. I say that because there's currently a consultation at the moment in terms of changes to contempt of court, and there are proposals to increase the range of sentencing options, so including community orders. But at the moment, there's no proposal to increase the maximum custodial sentence from 2 years. So that's the maximum, but of course that has to be justified in the individual case. At the moment, it's a fine is the only other sentencing option, and the maximum penalty is an unlimited fine. Normal sentencing principles apply, so the custody threshold has to be passed. The period of imprisonment must be for the shortest period possible. There must be consideration as to whether the sentence can be suspended. There is credit for a guilty plea, essentially, so an admission, and that will be a third reduction from what the sentence would otherwise have been. And mitigating circumstances will again be taken into account, as will aggravating circumstances. So all of these things will be familiar to anyone with experience of the criminal law and the sentencing exercises that the criminal courts undertake. There's also non-party costs orders, which again aren't just used in fraud rings. And Zoe's going to come on to talk about some examples of these in a moment. But just by way of an overview, a non-party costs order is a way of deterring or going after facilitators in a fraud ring. And the starting point is 46.2. And we've got Court of Appeal Authority on the screen now, setting out what the general principles are for making a non-party costs order. So the starting point is a non-party costs order is an exceptional order, but exceptional only means it's outside the ordinary run of cases where the parties pursue or defend them for their own benefit and at their own expense. Discretion will generally not be exercised against a pure funder, but if a non-party not only funds the litigation but controls or benefits from it, then justice will ordinarily require that they pay the successful parties cost of that litigation if it fails. The most obvious example is credit hire, but I won't say any more about credit hire because, as I say, Zoe's going to mention that in a moment. A few more cases on the screen dealing with it. It's important to know there's a wide discretion. So if you are successful in persuading your judge at first instance that you're entitled to a non-party costs order, it's unlikely to be overturned unless an error of law has been made. The discretion will not be interfered with lightly. The Supreme Court case of Travellers held that non-party costs orders won't be made against insurers as real parties, even when they directly fund and control the litigation. So they're not pure funders, they're controlling it because they're acting in the shared interests of themselves and the insured. So they're both working to the same common interest. It's not only in the insurer's interest to defeat the claim, but often their policyholder as well. As to causation, there is authority from Travellers that states there must be a causative link between the conduct of the non-party and the costs that were incurred, but that seems to have been subsequently doubted, and Turville, a Court of Appeal case, is preferred, where it was held that a strict consideration of causation is not actually necessary, and that may interfere with the court's wide discretionary power. And the only requirement is that it is just to make the order. So while you may be met with a causation argument, as we will see in some of the credit hire cases, that's not been something that credit hire companies, for example, have been able to successfully run. All right, so I'm going to hand back over to Zoe now, who's going to go through how these non-party costs orders apply in practice in regard to credit hire litigation.
Thanks, Jamie. So Jamie's already made the point that non-party costs orders are not a fraud ring thing or even a fraud thing insofar as they apply to all types of litigation. But we get them being applied for a lot in fraud and fraud ring cases because the defendant, as the losing party, isn't happy with a costs order that it can't enforce or a costs order that it can enforce in theory, but the claimant has no money. So what I find is non-party costs orders quite often come into play when the insurers don't want to take the risk of the tort of deceit or bringing a wider fraud ring into play or contempt of, they do want to feel like they're getting something out of the litigation other than just a paper win. So that's why you see a lot of these in fraud ring cases. I'm going to look at three cases. The first one, which kind of started the ball rolling, was a 2017 case called Select and Esure. And that was a case where at trial, the judge didn't make a finding of fraud or fundamental dishonesty, but he did find that he wasn't satisfied on a balance of probabilities that the claimants had even been involved in an accident. So unsurprisingly, Esure weren't happy with their costs order not to be enforced, wanted to do something to try and get their costs out of the credit hire company. Now, in that case, the total claim was pleaded at £30,000 and the credit hire element was some £23,000. And the judge at first instance made a non-party costs order to the effect of the credit hire company having to pay 60% of the defendant's costs. It went on appeal. It went on appeal to Mr. Justice Turner. He didn't overrule it on appeal, overturn it on appeal. And that was pretty much because the judge had followed the correct test set out in the statute, and he recognised that there was a very wide discretion. So he wasn't on appeal going to overturn the judge's decision. But what followed after the Select case was years worth of defendants trying to follow a similar pattern with a very mixed level of success. So there were some cases where they were getting these non-party costs orders, some cases where they warned against credit hire companies. And the two big arguments that they were facing were control and causation. So what the claimants were arguing was, look, that the credit hire company hasn't actually done anything to control the litigation insofar as they haven't interfered with the litigation. And the second argument that claimants were successfully running in these applications was a causation argument. In other words, that the case would have fought anyway, regardless of the credit hire argument, for example, because liability had been an issue. So there was a real mixed bag of results. And what you found was a few years after the Select decision, these were becoming less and less popular. That was until this year, where we had Mr. Justice Turner again in the case of Kindertons and Esure. And that was a first instance decision rather than an appeal. And he dealt head on with these two arguments about control and causation. And on control, he was basically saying, look, there is a danger of over-interpreting what it means to be in control of litigation. And he said that in the case in front of him, that the terms of the credit hire were enough, coupled with some evidence that was heard in that case, which was basically that the credit hire company in that case had discouraged the claimant from accepting an offer that had been made by Esure that they would provide an alternative replacement vehicle. And then on the causation point, Mr. Justice Turner rejected submissions that the defendant somehow had to prove causation on a but-for basis. So this decision was seen as being this real victory in terms of non-party costs orders for defendants. Excuse me. So a good decision, but my concern after this case was always that claimants are going to point to what was an evidential golden nugget that the defendant had in that case, where they got the concession from the claimant in cross-examination that the credit hire company had actually spoken to him and told him not to take the replacement vehicle. But then we had very recently, if we move on to the next slide, this case, the Pereira case. So the Pereira case is very recent. It was a decision that specifically looked at the relationship between Bond Turner and DAMS, Direct Accident Management, and or McCAMS. And it's specifically considered the commercial relationship between those two entities and the Adexo group, which is the larger group that basically owns both Bond Turner and DAMS. And there were 4 cases that were heard together at the same time. And although Bond Turner would not be happy with describing this as a test case, it was a test case because the solicitors on both sides had instructed the very best cost silks in the country to deal with this litigation. So it was 4 different claims, and there were very different reasons why the defendant had come out on top in that litigation and were looking for a non-party costs order. So in one of the cases, it had been dismissed at trial on the basis of liability. In one of the cases, the claimant hadn't paid a court fee and it had been struck out. And then in the other 2 cases, there had been an acceptance of a Part 36 offer that was considerably less than what had previously than what had been claimed late in the day. So there were all these different scenarios in which the defendant effectively had become the successful party. And what the case was looking at wasn't so much what happened in those cases in terms of the involvement of the credit hire company, but rather looking at the business relationship. And the court looked at the contractual terms and looked at the fact that the claimants were required to pursue the hire. They were required to pursue the hire diligently. They were required to use Bond Turner. And the court in that case came to the conclusion that there should be non-party costs orders against DAMS in respect of all 4 of those cases. And my view of that case is that unless and until Direct Accident Management actually change their terms and conditions, there are very good grounds in almost any case in which Direct Accident Management and Bond Turner are involved to actually apply for a non-party costs order. So that case has been a really big victory for defendants. Just moving on to the next slide then, please, Jamie. So very briefly on trends, what's happening? Personal injury claims. So you're finding less and less personal injury claims in fraud ring cases. And I think part of the reason for that is because they don't want you to be pleading fundamental dishonesty and having the whole claim dismissed. So I've come across this argument quite a lot now, where it's an exaggerated claim for damage or an exaggerated claim in respect of higher charges. And what the claimants are saying is, well, you know, even if I have exaggerated the damage to my car, you can't strike out or dismiss my claim because FD only arises if there's a personal injury element to the claim. So that's one trend that we've seen. And then so how they are making their money, if they're not making the money from the PI, is that you are having increasingly expensive claims for vehicle damage, storage and hire. And linked with that is the proliferation of motorcycle claims, which are in many ways the best thing to ever happen to fraud rings, certainly from a claimant's point of view, because motorcycles can be used in so many different ways to induce accidents. The car drivers or van drivers normally think they're at fault, or there's at least an argument in respect of contribution because most of them never see the motorcyclists. A lot of the time, they don't even know an accident has happened, if an accident has happened, because the motorcyclist will just tap on the door and say, you hit my motorcycle. And the other thing that makes them ripe is that motorcycles seem to be getting written off a lot easier, and they're targets for this in a different way than cars are, and that's what's opening up the gateway to these expensive hire claims. So at the heart of a lot of the motorcycle fraud rings, what you see is it is inevitable that the motorcycle is written off, that triggers the storage claim, it triggers the write-off, and it triggers the hire claim. And it moves on nicely to the point that Jamie's going to make in a minute about engineers. And then in terms of workplace accidents, so there's been again a spike in workplace accidents and fraud rings, particularly in the context of NIHL, so that's noise-induced hearing loss claims. So nowhere near as prevalent as road traffic fraud rings, but you are increasingly seeing fraud ring participation across other sectors. As I said at the beginning, back a few years ago, it was prevalent in the travel industry with holiday sickness claims, but that seems to have died down quite a lot. So those are the current trends we're seeing. And I think just to the final bit in relation to engineering evidence, I'm just going to turn over to you, Jamie.
Thank you, Zoe. Nearly at the end of our talk now, but this about engineering evidence is an important thing to bear in mind. Often on insurers' radar will be the medical experts that they have concerns about, where you read opinions in relation to, let's say, tinnitus or whiplash, and you just think, well, this is not credible, but these reports keep being churned out. But as I say on the slide, beware not only the dodgy medical experts, but also the dodgy engineers. In a lot of these cases where there is suspicions of fraud for vehicle damage claims, the main driver is getting an engineer to write off the vehicle. And the usual way a claimant will go about it, or the organizer of a fraud ring will say, we want a vehicle such as a motorcycle that can be written off easily, an impecunious claimant that then we can rack up a huge credit hire bill while we're waiting for the check to come in for the PAV. And that's the way that they get a lot of money for vehicle-based damage. The case is a case from the Central London County Court from 2021 before a deputy district judge, where an engineer, Mr. Levitt, was called to give oral evidence. And Mr. Levitt at the time worked for Evans Harding, a name that will be familiar to many of you. Mr. Levitt was asked questions about the report that was in the bundle and which bore his signature. And it was surprising, I think, to everybody in that case, that Mr. Levitt's evidence was that the first time he'd seen this report was as he was being directed to it by counsel in the hearing. He said that he'd prepared some handwritten notes, they'd gone off to the Evans Harding office, and then someone had prepared a typed report and transposed his signature onto it without his authorization and authority. Mr. Levitt then opened up his handwritten notes during the course of the trial, and they were subsequently ordered to be disclosed because he was referring to them whilst giving oral evidence. And it transpired that there were material differences between his notes following his assessment and the report that was within the bundle. So, for example, the salvage figure he'd noted down at about £665. In the bundle, the typed report said it was £266. So that's an extra £400 for the claimant right away. The extent of the damage within the typed report was more significant than he'd indicated. There were lots of crosses on the matrix that they use in these reports that he hadn't identified within his notes. And crucially, on the roadworthiness issue, the typed report said that the vehicle was unroadworthy, and Mr. Levitt in oral evidence accepted that that was basically based upon what he'd been told in his instructions, i.e. the claimant solicitors had told him the vehicle is unroadworthy. And he'd been unable to independently verify that from his own assessment because he couldn't access the vehicle because he didn't have a key and the battery was flat. So he couldn't test the brakes, he couldn't test the steering, he couldn't test anything within the vehicle. And he just said, well, they tell me it's unroadworthy, so it's unroadworthy. I think this is a really interesting case because it gives an insight as to what can go on in the preparation of some of these reports, and shows what evidence can come out if engineers are called and their evidence is tested during cross-examination. So I think it's a very interesting case, and the basic point is, if it doesn't seem right, don't take it at face value, dig into it, have your own engineer have a look at the vehicle, or challenge what it is that the claimant says. That concludes our presentation. So I'm now going to hand over to Beth Corns, who is going to give us a case law update on fundamental dishonesty, along with some practical tips. So thank you, Beth. Over to you.
Thank you very much, Jamie and Zoe, for that very interesting talk. I'm just going to share my screen so that you can see the PowerPoint. So I'm going to be speaking for the next 40 minutes or so on recent case law in fundamental dishonesty cases. And what I've tried to do is sort of theme those cases into these 5 topics. So we'll go through each of these 5 topics, looking at those cases and hopefully getting some practical hints and tips on how we can apply those to other cases going forward. I'm going to begin with pleadings in FD cases and go slightly backwards. This is not particularly recent case law, but it sets out the background. And we'll all be aware of the cases of Howlett and Mustard and Flowers, which set out that fairness sits at the heart of the notice requirements of fundamental dishonesty. It need not necessarily be pleaded, but the insurer should positively allege. I'm going to have to stop that, sorry. That's not a good start. Sorry, I'm having some issues with sharing the screen. So we'll begin with pleadings in FD cases and the well-known cases of Howlett and Mustard and Flowers, which set out that fairness sits at the heart of the notice requirements on fundamental dishonesty. And insurers need not necessarily plead it positively in a defence, but certainly by the time one comes to the end of trial, the claimant must have been given adequate warning of and a proper opportunity to deal with those allegations. How has that then been addressed in the recent cases? Well, Jenkinson and Robertson is one case in which this has come up. This was a case where a litigant in person brought a claim for damages following a road traffic accident. Fundamental dishonesty hadn't been pleaded, but in pre-trial correspondence, assertions were made that the claim was exaggerated and unreasonable. The claimant, again a litigant in person, had made some requests of the defendant in this case to clarify, but the defendant had refused to do so. By the time we come to trial, again, it's not expressly put to the claimant that he was being dishonest. It was put to him that he wasn't suffering to the extent he said he was, but it wasn't put to him that he was being dishonest. Notwithstanding that, he was ultimately found to be fundamentally dishonest at trial, and perhaps unsurprisingly, he appealed that decision. This came before Mr. Justice Chowdhury, who held that it was in the interests of basic fairness that a claimant should be given adequate warning of and a proper opportunity to deal with the possibility of a finding, as we've already seen from the case of Howlett. He noted that the consequences of the finding are severe, and so it's proper for claimants to be given an opportunity to respond to those allegations. There is, he said, a world of difference between putting to the claimant that he was not suffering the pain he now alleges, compared with an allegation that he was dishonest, essentially. This case is helpful in that the judge went on to provide some guidance on the sorts of things that one ought to be saying to claimants. in order to provide them with the notice that is required. He said that a claim that's unreasonable could be misconceived rather than necessarily dishonest. Exaggeration might be because the claimant is mistaken, that they think that losses arise out of the incident when in fact the court finds that they don't. And finally, that asserting that a claim is not credible or is exaggerated is not sufficient without more to be an unequivocal allegation. So some takeaway points from the case. The basic principle is retained, essentially that there is still a discretion as to how and when fundamental dishonesty is raised. The extent to which a defendant has to ensure that the claimant understands that it's being alleged will vary. It is very likely that the burden on the defendant will be higher if the claimant is a litigant in person, because he doesn't have solicitors or a barrister to explain it to him on the day of trial. Simply alleging a case is unreasonable or exaggerated or not credible, so skirting around the issue somewhat, is also unlikely to be sufficient. And the final 2 points on this slide, that defendants are required to indicate the source of the dishonesty, I'm going to come back to in my next topic, which is on finding and defining FD. And so we'll come back to those issues at that point. First, though, I want to talk about the case of Kajanu in relation to this theme. This was a claimant who was remanded at HMP Bedford. When he arrived at HMP Bedford, he had a finger injury, and it was his case that there was a delay in providing him with medical treatment, and that delay meant that repair of his finger injury was ultimately unfeasible. In the context of his PI claim, the claimant alleged that he had sustained the original injury to his fingers, defending himself from an attack by his wife. In fact, the claimant in this case had attacked his wife, and he'd sustained the injury to his finger resisting arrest, and he was actually imprisoned for the attempted murder. Further, the schedule of loss that was put in on the claimant's behalf assumed that the claimant was still living and working in the UK, despite the fact that before it was served, he'd been deported to Romania. The defendant alleged fundamental dishonesty in that case, based on first, this discrepancy or real dishonesty as to how the original injury had happened, so the mechanism of the finger problem, and second, in terms of the way in which the claim was presented. So the claimant pursued a future loss of earnings claim on the basis of UK salary rates, when he knew by this point he'd been deported to Romania. And as a similar point, that the required surgery that he would, if he had it, he would have it in Romania now that he lived there, would be cheaper than if he'd had it in the UK, which was what was being claimed. Based on those 3 points that the defendant put forward, the claimant was found to be fundamentally dishonest. And again, perhaps unsurprisingly, he appealed against that decision. We then get this 5-stage test set out for the Section 57 defence by Mr. Justice Ritchie, which is very helpful. First, that the Section 57 defence should be pleaded. Well, we've already had a look at the authorities on that point. Second, of course, the standard burden of proof. Third, that the finding of dishonesty by the claimant is necessary. And there are 2 parts to that. First, to find on the evidence what the claimant's state of mind was at the relevant time. And second, to apply an objective standard to decide whether the claimant's conduct was dishonest by the standards of ordinary people. The 4th point goes to the fundamental, to what extent the dishonesty will be fundamental. And what was said was, to be fundamental, it must relate to a matter central to the claim. Something that's incidental or collateral, a sort of sideline issue, is not sufficient. And finally, 5thly, as to the effect of the dishonesty, to be fundamental, it must have had a substantial effect on the presentation of the claim. Based on that 5-part test, Mr. Justice Ritchie held that the claimant was not fundamentally dishonest. the dishonesty about the crime and the mechanism of the original injury wasn't fundamental to either liability, given that this wasn't a claim as to how the original injury had happened. It was a clinical negligence case, and it also wasn't fundamental to quantum in the civil claim. It didn't affect the liability, which was to be determined on expert evidence, not the claimant's factual evidence. This is a direct quote lifted from the judgment, and this goes more to the second two of the 3 points made by the defendant. And what was said was that the incorrect pleading, the failure to quantify the claim properly, is not something that amounts to fundamental dishonesty, but actually it wasn't dishonesty at all. It was an example perhaps of incompetence, of carelessness, of omission by the claimant solicitors. It may be, he said, a moot point whether that includes the dishonesty of the lawyers. That wasn't something he determined, but it did not go, he said, to the claimant's honesty. So some points to take away from this case. For dishonesty to be found to be fundamental, it needs really to go to the heart of the subject matter of the case. Irrelevant or sideline points are not, in all likelihood, going to be found to be fundamental. There's also this distinction that's been made between the incompetence and carelessness on the part of a legal team and the conduct and the belief of a claimant that might amount to them being dishonest. What the judgment didn't do was say that in no circumstances can a claimant be found fundamentally dishonest based on inaccuracies in the pleadings or in the schedule. It's essentially a reassertion of the well-known test from Ivey and Genting, the actual state of the claimant's knowledge or belief, and whether the claimant and the way in which they put their claim forward led to an untrue presentation, or whether it's simply an error on the part of the legal team. On the same theme of how we determine, how we find FD, there's this case of Denzel. This was an appeal that came before Mr. Justice Friedman. At the original trial, the claimant in his witness statement and in his oral evidence referred to a minor head injury that lasted for about 4 days, but that minor head injury had not formed part of his pleaded case. Now, the claimant was found to be fundamentally dishonest and appealed, and it was overturned on appeal. What was found was that this 4-day head injury was not fundamental. It didn't affect the value of the claim, and it didn't affect how the case had been presented. And so what was concluded was that applying the language from the Lowcock case, this did not substantially affect the presentation of the case, either in respect of quantum or liability, or both, in a way which potentially adversely affected the defendant in a significant way. So what this case really tells us is that even if there might be discrepancies, inconsistencies in the evidence, if this goes to minor short-lived injuries or the like, fundamental dishonesty is unlikely to be made out. It essentially confirms that incidental collateral matters are unlikely to result in an FD finding, even where those inconsistencies can be identified. I'll move on to experts and the very interesting case of Moyepa. This was the case where the claimant was a former soldier in the British Army, and he pursued a claim against the Ministry of Defence, saying that he'd sustained a non-freezing cold injury in the army, and ultimately that resulted in him being discharged on medical grounds. He made various assertions when he was examined by the experts. He said that he had constant pain in his hands and feet. He was essentially housebound. He couldn't walk without a walking stick or without the assistance of his wife. He said that he lived with his wife and she provided him with a good deal of care and assistance. He relied very heavily on her. They had a disabled daughter, and he said that he was unable to care for her since he had been injured. he said that he could no longer work due to the injuries that he'd sustained. The defendant then arranges for several periods of surveillance to be carried out and undertook intelligence searches. They then plead a positive case of FD for various reasons that came out of those investigations. The evidence regarding the use of him using a walking stick was inconsistent, and he was recorded at various times dancing and walking without the use of a stick. What also became clear was that the claimant and his wife did not in fact live together, and so when pursuing this fairly substantial claim for the care that was allegedly being provided by the wife, this was found to have misled the care experts. The records, the DWP records were obtained, and this is something I'm going to come back to later on as well, where these records can be invaluable sources of information. Here, the claimant signed a declaration to the DWP that he provided over 35 hours of care per week for his disabled daughter, whilst at the very same time claiming in the context of this case that he was unable to care for her and that he, in fact, needed a significant level of care. The claimant's wife was found to be working a significant number of hours per week and physically unable to have carried out the levels of care that she alleged that she was doing. Again, video surveillance showed the claimant out and about shopping with his children, not displaying the sorts of mobility issues that he was claiming. He was found to be fundamentally dishonest at trial, and there was deep and extensive criticisms of the claimant's experts in that judgment. The quote that I've produced on the slide is that the defendant's experts painted a coherent and consistent picture of conscious, deliberate, prolonged and significant exaggeration, which I much prefer to the overly benign, and I regret to say at times partisan, analysis of the claimant's experts. And he found that Mr. Mayepa could walk, could dance, could do activities around the house, and the use of the walking stick was merely a prop. And the claimant's experts faced real criticism in that case for being, as is produced in the quote, partisan, and at times neglectful of their Part 35 duties to the court. So some takeaway practical points from this case. Firstly, in terms of assessing claimant expert reports, we should be considering whether the opinions and recommendations in those reports are supported by and underpinned by logical and reasoned justifications and evidence, whether, where relevant, the expert has included or considered a reasonable range of opinion, and whether an expert is open to changing or qualifying their opinion when new evidence comes to light. And I'm particularly thinking here about surveillance evidence that may well contradict what is being reported by claimants in terms of mobility problems. And finally, whether that expert has a balanced portfolio, by which I mean between claimant and defendant instructions. The points that I've put down in terms of defendant experts really mirror those in relation to assessing the claimant's experts. Always be encouraging experts to read and reread Rule 35 and the practice direction so that they are well aware of the duties that are owed. Ensuring that their opinions and recommendations are founded on the evidence and underpinned by logical justification. Again, that they provide a reasonable range of opinion where relevant and are prepared, if necessary, on the evidence to amend or qualify opinions. And again, considering the balance, the split between claimant and defendant work can be helpful. A fairly brief topic that I want to cover is on interim payments, and this is the case of Mahmood. The claimant was injured in a motorbike accident. He suffered some quite serious injuries and claimed that he lacked capacity, although that was disputed between the parties. He'd already received an interim payment of £10,000 and he applied for a further payment of £75,000 for treatment that had been recommended to him by the experts. After that interim payment application had been made, the defence was amended to positively plead FD based on some medical and surveillance evidence that had been obtained. So the interim payment application made by the claimant failed, and this was the decision with reference to CPR 25.71. The court can only make an order for an interim payment where one of the following conditions are satisfied. And the relevant one here is subsection A, where the defendant against whom the order is sought has admitted liability to pay damages. Well, in response to the application, the defendant relied on the amended defence, which pleaded FD, to submit that if that FD allegation succeeded, then the claim in all likelihood would be dismissed. And the defendant therefore wasn't admitting at all any liability to pay damages, notwithstanding that primary liability for the accident had been admitted. The court was asked to consider whether the issue of FD could be resolved on a summary basis. It could not, so that was a matter for trial. And as a further rationale for the decision, CPR 25.74 requires that the court consider what a reasonable proportion of the likely amount of final judgment would be. Well, again, in circumstances where FD is a live issue, and it may well be that the claimant recovers nothing, it's impossible for the court to ascertain what a reasonable proportion of the likely amount of final judgment would be. So some points to take away from this case. Really, what this case does is give reassurance to taking a robust approach against interim payment applications where FD is a live issue. The court recognised that some injustice might be caused to the claimant. He was after money for treatment that had been recommended, but still rejected the application. It's also a case which makes us think about the timing of an FD pleading and perhaps where an amended defence might be needed. It can be a useful tool, as it was in this case, for defending such applications. And so it's worthwhile considering if that is the time for amending the defence if needed. The next section or theme that I want to talk about is substantial injustice, and this is an area where there have been a number of really interesting cases recently. The first one that I want to talk about is Sean Wild, which is a Manchester case. And the claimant sustained undisputed, very serious orthopaedic injuries. He had over 20 surgeries. He had a shortening of the right leg. The schedule was pleaded at just under £6.5 million. The claimant had disclosed a day in the life video which suggested that he had profound disabilities that included a practically immobile left arm, near constant reliance on a walking stick, a maximum walking distance of between 100 and 200 yards, reliance on a mobility scooter, and that he wasn't able at all to resume what he previously enjoyed by way of hiking, climbing and base jumping. The defendant disclosed surveillance evidence, and that demonstrated him walking further than he said he could without a walking stick. It never showed him using a mobility scooter, and it showed that he was able to ride an electric bike to the shops. At that point, the defence was amended to allege FD. They proceeded to trial in this case, and the claimant called 19 lay witnesses to attest to his level of disability. And it came before His Honour Judge Sefton, King's Counsel, who made these findings. He rejected the claimant's explanations, going to mobility issues, fluctuating symptoms, and what he said to be innocent miscalculations when he was thinking about how far he could walk. The judge specifically found that he'd gone up Mount Snowdon on an electric mountain bike, and that was something that the claimant had specifically denied in his reply to the amended defence. And the judge also found that he'd been base jumping since he was injured. The value of the genuine claim was high. It would have been, the judge found, just under £1.25 million. But he went on to find that that there was dishonesty, that dishonesty was more than mere exaggeration, which might be excused, and that the dishonesty was dishonest by the standards of ordinary people. This really went to the central issues in the case, and these weren't incidental or collateral issues, and hence fundamental. And the judge found that the effect of that dishonesty on the pleaded value of the claim was striking. But for the lies, the case was straightforward. Trial would in all likelihood have been avoided. So what was said then about substantial injustice? Well, Section 57(2) of the Criminal Justice and Courts Act 2015 states that the court must dismiss the primary claim unless it is satisfied that the claimant would suffer substantial injustice if the claim were dismissed. The claimant argued in this case that denial of compensation would amount to substantial injustice, but that was rejected by the court. His Honour Judge Sefton rejected the assertion that loss of legitimate damages in itself was sufficient to fulfil the substantial injustice test. And that was the case even here, where the legitimate damages were significant, well in excess of £1 million, where the claimant had limited earnings capacity and genuinely did have an ongoing need for care and for equipment. What the judge said in this case was it's helpful, can be helpful, to consider what somebody who is similarly injured would do if they didn't have anybody to sue for what had happened to them. And so in this case, the claimant's basic needs for aids and for equipment would be met by the state. The claimant's team made the point that the defendant hadn't admitted liability, they'd made unsuccessful allegations of contributory negligence, but the court found that this had little bearing on whether the claimant would suffer substantial injustice. It was essentially irrelevant to that question. And the thrust of the judgment really can be summarised in the final line, which is Mr. Shaw has only himself to blame. He lied to the experts, he lied to the court. That was the findings that were made, and he'd been warned by this in correspondence sent on behalf of the defendant. He continued to lie and be unrepentant. Some takeaway points from this case. Putting the claimant on notice, yes, by way of pleading FD, but also by way of those sorts of warning letters, might be relevant to the substantial injustice considerations, so they are always worth thinking about. Don't be too cautious or afraid if the claimant presents a significant number of lay witnesses to support their claim. In this case, there were 19. But many were only witnesses to a small part of the overall picture, and relatively little weight was given to their evidence. Bank records were key in this case, and again, this goes to applications for records that you think might be relevant. The bank record showed that the claimant was able to travel abroad when he denied being able to do so in the way that it turned out he did. And so a robust approach to disclosure is key, and in this case applications were required, so give some thought to whether they'll be useful in other cases. Don't be afraid to challenge if the claimant's alleging that he's said something to his solicitors, essentially in his defence, to say that he's not been dishonest. In this case, he claimed to have told his solicitors that he had climbed Mount Snowdon. On the basis of what he said, the defendant asked for those privileged file notes, which were provided, and they demonstrated that the claimant actually had never told his solicitors what he claimed to have done, which further undermined his credibility. And the real takeaway, I think, from this case is that even where the injuries are severe, and even where legitimate damages might be very high, well over £1 million in this case, the court was still not prepared to find substantial injustice, including, the court said, with regard to this situation where lots of people might similarly be injured, don't have anybody to sue, and their basic needs will be maintained by the state, and that will be the same for this claimant. The next case in terms of substantial injustice is Kirsty Williams-Henry. She fell from a pier. Liability was resolved. There was a split liability decision, and the case proceeded to trial on the issue of quantum. It was clear that she'd had a moderately severe brain injury and multiple orthopedic injuries. She'd received some interim payments. The claim was pleaded at over £3.5 million on a 100% liability basis. Initially, she'd done fairly well and returned to work, but on the recommendation of the case manager, she'd stopped working, and the court found that had been inappropriate. She had obvious injuries and she had some severe mental health issues by the time of trial, and those made her a poor witness. But even in light of those issues, the court found her fundamentally dishonest, particularly with regard to DWP records, social media, and surveillance. The court concluded that the problems that she was reporting were largely fabricated. She'd exaggerated the effects of her injuries in a DWP claim, and she'd lied on a life insurance application form, and this demonstrated that she was prepared to lie for financial gain. The court found that she was grossly exaggerating her injuries. She claimed that she'd been struggling at work, but that could demonstrably be contradicted by reference to the appraisals, and she'd failed to disclose that she was able to go on holiday, attend various events. So Mr. Justice Ritchie set out 8 material factors when considering the substantial injustice test, and I've listed those on the slide. The first is the amount claimed when compared with the amount awarded. Second, the scope and depth of the dishonesty. 3, the effect of the dishonesty on the construction of the claim, including cost consequences for both sides. 4, the scope of the claimant's genuine disability. And this is interesting when we read it in light of what we've already seen in the case of Shaw. In this case, what was said was, if somebody is very seriously injured, the deprivation of damages would transfer the cost of care to the NHS and other services, and that would be more unjust than if somebody was less seriously injured. And I'll come back to that point shortly. 5th, the nature and culpability of the defendant's tort. 6th, what the court will do in relation to costs. 7, the interim payments. And finally, 8, the overall effect of the claim on the claimant's life. And that factor at 8 was particularly important in this case because the claimant's mother and one of the experts gave evidence that the claimant had indicated that she would commit suicide if she was found to be fundamentally dishonest. The court found that indication was relevant to the question of substantial injustice, but still decided that there would be no substantial injustice in this case, and did deprive the claimant of the valid amount of the genuine claim, which would have been just under £900,000. Some of the reasons are given at the bottom of the slide. The level of the inflation of the claim by over £1 million, the scope of the lies, that the claimant was unwell, but actually had made a good recovery, and so depriving her of damages was not expected to burden the state to any particular extent. The defendant's tort was at the lower end of culpability, and she was capable of work. The final theme that I want to go through is this case of Thakar, and a warning really that's been given to defendants on what is likely to happen when FD is alleged but fails. The claimants were injured in this case in an RTA, and a defence was put in that pleaded that the claimant's credibility and honesty would be challenged at trial, but it didn't positively plead FD. We then come to the CCMC, and the defendant applied to amend the defence to specifically plead FD, but that application was refused. At trial, allegations of FD were not put to the claimants. That was not pursued for whatever reason. judgment was entered for the claimants. Thereafter, the claimant sought indemnity costs from the date of the CCMC based on the fact that at that point, allegations of FD were raised. That was refused and the claimant appealed, but the appeal was dismissed. The court found there's no presumption in favour of an order for indemnity costs, but issued a pretty stark warning to defendants that a failed allegation of dishonesty will very often lead to the making of an indemnity costs order. It didn't in that case, but the warning was there, and perhaps in that case, in the circumstances where it was raised at the CCMC but then not pursued at trial, it was perhaps not the clearest example of where FD was put and failed, and perhaps that was one of the reasons why that argument failed. But notwithstanding the eventuality of that case, the warning is there. So those are the themes that I wanted to go through, and I just wanted to finish off by trying to draw together some of the takeaway points that I've been referring to as we've gone through. Firstly, in terms of pleadings, if there is enough evidence to justify it, FD ought to be pleaded. If it's not, adequate notice must be given. In terms of the types of issues that might lead to an FD finding, credibility on one issue doesn't necessarily mean a claimant is unlikely to be believed on another, and dishonesty on collateral issues, again, should not be treated as being particularly relevant to credibility on central issues, nor should it result in a fundamental dishonesty finding. It can be helpful to canvass the views of experts in conference, and they're the ones that have seen your claimant, and they may have a view on how they might fare when being cross-examined, so that can always be helpful. When faced with interim payment applications, consider these carefully where FD is a live issue. Is this perhaps the time to amend the defence to plead FD? And certainly where there are grounds for pursuing FD, there is justification in taking a robust approach. And finally, in terms of the substantial injustice points that I've touched on, even where injuries are severe and where genuine damages are high, the courts have still been reluctant to find in favour of claimants on this point, including for those who are really very vulnerable. Perhaps there is scope for very seriously injured claimants to succeed on that point. And I'm thinking particularly, if we just go back very quickly to these points from the Williams-Henry case. Point 4, the scope of the claimant's genuine disability. If very seriously injured, the deprivation of damages would transfer the cost of care to the NHS and other services, and that might well be considered unjust. Well, that in some ways, I think, could contradict what was said in the case of Shaw, which essentially was that transfer of the burden to services can be a factor in not finding that there would be substantial injustice because the basic needs of the claimant can still be met. The second point is I'm finding it difficult to reconcile the idea of somebody who is genuinely so seriously injured that they're going to put a real significant burden on the state in terms of care benefits for being unable to work, but who also in the same way is found to have exaggerated those injuries to the extent that's required for an FD finding. But perhaps that case exists. And very finally from me, always consider the balance of pursuing finding of FD with the potential risks, particularly they're thinking about the cost risks. So that's all from me. That concludes my talk on the recent case law. I'm now going to hand over to Leanne Jones, who's going to give a talk on the use of social media in FD cases.
Thank you, Beth. Yes, my talk follows on nicely from yours, actually, Beth, in outlining some recent case law in FD cases generally. I'm going to talk to you about in those types of cases, how judges have received and utilised social media evidence, and how we can maximise success from such evidence. I'm just going to try and share my screen. So, social media and fundamental dishonesty. There we go, that's better. Are we living our best lives? So we all know, we'll all be familiar on one platform or another as to what social media is and how it's used, but just for way of comparison between the various sites or platforms, these figures are from early this year, but it just gives you an insight looking down those figures as to the sheer volume of people in the UK that are using the various social media platforms. So it's perhaps unsurprising, looking, just casting your eye down those figures, that we can glean what people are up to perhaps best from their social media platform. Now, in terms of how much truth is in that, we'll move on to that now. So these are some quotes that were taken from a study that was done in Singapore into the effects of Instagram use, social comparison and self-esteem on social anxiety. It was a 2020 survey study, and you'll see from those quotes that the general consensus is people compare themselves with others in terms of appearance, ability, popularity, social skills, and such comparisons trigger strong psychological responses, particularly when others selectively present more positive information. And I think it's that age-old saying of living one's best life online. And it's true that from these studies, we know that people get fear of missing out. We're only human. It prompts a reaction within us to post more positive information. And that, I think, is where the arguments for the claimant as to the reliance that can be placed on social media posts come from, which takes me to the next slide. So defendants will get social media evidence, will make inquiries. Defendants will think we've got a smoking gun, we've got the claimant caught out in a lie here because her Facebook or Instagram shows her doing X. Caution, you need to be aware as to what these counter arguments are. So the claimants will often say it's not real life. People lead a secondary life online. Social media posts have to be seen in their context and their purpose must be understood. Even if they're reflecting reality, they can only ever be a snapshot. And the upload time is not necessarily the activity time. There is likely to be a positive spin or a gloss to the post. And again, that goes back to whether we are merely showing posts where we are living our best lives. So those are common themes that are argued by claimants. In my experience, they're more likely than not to fail if social media evidence is good enough, because the claimant, of course, will be on the back foot and can appear to be making excuses. So let's look at some cases where social media has been considered by the court. So Palmer is the first one I'm going to talk to you about. This was a High Court trial, RTA on the M25 in June 2024. Liability admitted in this one. The claimant was claiming that she'd sustained whiplash, mild traumatic brain injury, post-traumatic migraine, audiovestibular injury, somatic symptoms disorder, and she valued her claim at 2.2 million. Defendant, on the other hand, said the basis of the claim was fundamentally dishonest, there'd been exaggeration, and the claim was worth approximately £5,000. The defendant relied on 700 pages of social media evidence. It's worth noting the defendant only pleaded fundamental dishonesty in the counter schedule 3 weeks before trial. So that feeds well into Beth's talk as to pleading in fundamental dishonesty cases. So pre-accident, this claimant was training for a marathon. She said in her witness statement she had not returned to running post-accident, but the social media posts showed her running at a 10K Bear Grylls event. The judge accepted that the claimant had completed the course slowly at a gentle jog or walking pace, 3 hours 40, and missed many of the obstacles that she ought to have done but for the injury. It was found her witness statement was not dishonest when considered in context. So the claimant had said she could jog. Her witness statement had said that she hadn't returned to running. And in terms of the context that the judge saw that in, it was basically that she hadn't ever said she couldn't do a gentle jog or a walking pace, which is exactly what her evidence was in response to that Facebook post. And I think that's an important message to take away. Another example that I have, just pausing there, I had a case where we had Facebook posts of a claimant who had said, I've not returned to my hobby of motocross because of my injuries that I sustained. We'd got photographs of him in full motocross, I want to say uniform, but that shows that I know nothing about motocross. But it certainly looked as though he was participating in the event. And the evidence that came to light from the claimant was it's a real friendly atmosphere. I've been part of this motocross club since I was a child, and I was there to support my friends and family who were taking part in the event. And it turned out he wasn't actually doing anything, or we certainly couldn't prove that he was doing any kind of motocross. So that goes there again to feed into consider it in context. Just by way of an example, looking at this photograph, if we were to do a deep dive into claimant social media and saw this on Instagram or Facebook, instinctively you would think, well, this is a claimant who says they can't run. Look, they're out for a run. Let's get this. This is our smoking gun. Well, the outfit would make you think that, the phone on the arm. But in reality, it could be jogging or even walking, listening to a podcast or an audiobook. We don't know distance, speed, intensity. It's worth bearing in mind that if it's accompanied by text, that would perhaps make a difference. You often see when one is living one's best life online, things such as personal best at the gym, lifted X amount of kilograms, or personal best in a 10K or a half marathon, and they'll give you the time. So in showing off, they're doing themselves a disservice in terms of getting caught out in some ways. But if it's accompanied by text, it's much better than a photograph that can be perhaps explained away. Even better than that is videos, and the new social media. I say new, it's been around for a while now, but TikTok seems to be the trendy one lately. And I had a case where a semi-professional golfer was saying, I've not been able to return to golf. I've not been able to return to teaching, which I also do, these golf lessons. And yet he was on TikTok and YouTube videoing said lessons, where he was seen swinging the club, demonstrating various different golf skills. And obviously, he can't talk his way out of that because it's there to be seen. So video is much more compelling. But I'd say don't fall into the trap of assuming, if you've only got a photograph, that, aha, we've caught the claimant out. Back to the Palmer case, sorry, I'm jumping around here. The claimant was ultimately successful in that case. Judgment was obtained beating the Part 36 offer. The claimant argued social media, not the complete picture. The purpose, as we all know, is to get likes, and it's not perhaps a factual account. The claimant's expert, Dr. Murphy, in that case was accepted. What was said is it's uncontentious that people post positive or upbeat messages. And it was held that a level of caution need to be expressed, but the post can't simply be dismissed as not true or unreal, because they undoubtedly showed the claimant taking part in some capacity in that event. So that was a case that wasn't successful in relying on social media evidence. Just looking at cases where it has been successful, Wye Valley NHS Trust and Murphy, fairly recent decision this year. It was a clinical negligence claim following repair to a left bicep injured in a rugby game. The claimant had verified the particulars and schedule of loss by statement of truth, saying his injury had affected his ability to work and that he could not play rugby. The true value of the claim was actually 1% less than that was actually claimed. FD was alleged by the defendant and the claimant's solicitors withdrew. The claimant ultimately failed to attend the trial and the defendant applied to have him sent to prison for contempt of court. The defendant in that case produced local press reports, social media posts that clearly showed this claimant had been playing rugby and had returned to doing so in 2017, long before he was interviewed by his treating doctors, where he said, "I can't return to playing rugby." In addition, the rugby club had its own social media pages where it showed the claimant playing several games. Throughout the period, he was still telling doctors he couldn't play. And perhaps rather unsurprisingly, he was found guilty of contempt of court. Another recent decision is that of Thomas and Owen. It's a Cardiff County Court decision. Claimant brought a PI claim following a road traffic accident, liability admitted, ongoing symptoms with no physical cause. Defendant got surveillance evidence showing the claimant walking to community exercise classes, playing in the park with her nephew and shopping. Social media showed her travelling abroad, and her Strava exercise app showed her walking each day, not at a particularly slow pace. So I'll pause there to say I'm covering social media in this talk, but please don't forget things like Strava. I'm sure there's various other exercise apps, particularly when most people now have an Apple Watch. There's apps where people compare their exercise, daily steps, whether they've closed their exercise and activity rings, and a lot of people will post about that. So it's worth tracking those things, because of course then you're not faced with a situation where you've got an image, you've got actual timings, you've got distance. It's not subjective anymore. You can say to a judge, look, this is the pace that this claimant was out for a jog. So please bear that in mind. Back to this one, she wasn't walking particularly slowly. There was a blog on social media that showed that she had done a Four Fountains walk in the Brecon Beacons, where she elected to take an optional and strenuous detour. The defendants in that case made an application of social media posts which were behind a privacy setting. So another takeaway point from this case, just because it's behind a privacy setting doesn't mean you're not going to get it as a defendant. The claimants aren't safe from that. The judge found a significant difference in the description of symptoms given to the DWP and the treating doctors to that which the claimant's social media revealed. No explanation for this, and the claimant's credibility was undermined. The description in that case that had been given to the experts was that she was at a significant general restriction, even on a good day, and the judge held it was grossly inconsistent with the decision to undertake that four waterfalls walk, unsurprisingly, a finding of FD in that one as well. A few more cases detailed there, perhaps in less detail. We've already covered, thankfully, with Beth, the Mwapa and MOD case, which is in the middle there. In that case, social media was utilised alongside the surveillance that Beth mentioned, showing that the claimant was dancing at a wedding, driving, shopping, and frankly walking without the stick that he said he needed to be able to walk. There's then the Roberts and Kesson case at the top there. Claimant claimed his taxi had been written off and he'd only be able to obtain the salvage value for it, but the social media post showing him selling it for £7,000 with an MOT certificate. And then the bottom there, the Collie and Hull University Teaching Hospital. Claimant asserted she could only walk for 5 to 10 minutes, so was often confined to a wheelchair. Social media posts showed her snowboarding, cycling, ice skating, and performing on stage. So looking at those cases as a whole, the social media evidence works best where the claimant has made a definite allegation. I cannot do X, and then they are shown to be doing X on the posts, videos, or whatever else. For example, walking, I can't walk without a stick, I can't go running, I can't return to cycling. If you can find evidence of them doing that when they said they couldn't, that's your smoking gun. The courts will accept social media evidence as showing that the claimant has been dishonest about their injuries and or exaggerated the symptoms. The Palmer case went wrong for the defendant, but we've seen from the other cases that we've been through that the social media evidence has been deployed more successfully. I think the takeaway is it's not always the smoking gun you think it's going to be. So weigh up in the balance whether the social media evidence is good enough before using it. And we'll come on to that a little more in a moment. So how should defendants use social media? Make inquiries early, flag whether further investigations required. There will be the ability to go back and check if posts have been deleted, but dishonest claimants are likely to lock down or delete that social media when they bring a claim and they know they're lying about it. So the earlier the better in terms of securing that evidence. Ensure that all inquiries are properly evidenced. It's not good enough to have screenshots. You need, even screenshots for an intelligence report aren't good enough. I'd say set it out in a statement. What were the nature and the results of the inquiry? Concentrate on facts. Videos in particular, as I've already discussed, can be illuminating, and get the metadata if needed. Again, we're dealing with a scenario where people are living their best lives online, and I keep coming back to that phrase, but if a person, a claimant, is having a particularly dull month or particularly dull year, they may post a photo or a video showing them cliff diving in Ibiza in years gone by. And of course, that's one way you'd think, I've caught them out, here's my smoking gun. The claimants quite often say that doesn't show the prognosis period, that doesn't show the time where I said I couldn't do these things. So ask for the metadata if those sorts of comebacks are achieved from the claimant. The final point on this slide, used in conjunction with surveillance evidence, social media posts can be particularly successful. In Palmer, the surveillance didn't help the defendant, but we've seen from the other cases of Mwapa and Thomas that it did. And the surveillance goes hand in hand with the social media if it shows that they've made that positive assertion that they can't do something and they're clearly seen doing it. Quite often you get them leaving, which would be a brilliant smoking gun, the defendant's medical examination, where they've said, I can't walk without the assistance of a stick for more than 50 yards or whatever the case may be. And the defendant's got them under surveillance, showing them hopefully skipping out of the examination building. So it's those sorts of things that we need to complement the social media evidence. My final slide is to evaluate the evidence. Now, I've already touched upon this, but if there are just a few posts and they're perhaps just photographs that can be explained away, that's not going to be massively helpful. It's going to be a judgment call as to whether the social media evidence alone is enough, or whether that surveillance backs it up, or whether taken as a whole, a claimant might, for example, have numerous social media platforms, and you've got a whole host of evidence from those which clearly shows that he or she is lying. So it is a judgment call. They're not always helpful, as I say, if you only get one or two, but they can be particularly helpful showing exaggeration, especially when they're confirmed by other sources, so witness statements, expert reports, surveillance, GP records, DWP records. And what I mean by that is, can you find a dated post, for example, on Instagram? It often says things like 33 weeks ago, so-and-so posted this. If you can specifically date that post to a week or a day, for example, in the witness statement, where this claimant is saying, I was supposed to be going on holiday this week and I had to cancel my holiday because I was in so much pain I couldn't fly, or I couldn't enjoy the holiday. And then you've got social media posts for that week showing claimant living their best life, bungee jumping on holiday or whatever it is. Or even if they've said that they can't take part in a prearranged race for life even, and you've got that on the exact date, that's much more powerful than just putting in the photographs from social media. So it is really about evaluating that evidence, making a judgment call as to whether it's good enough to support the allegations of fundamental dishonesty. And of course, if you require any assistance on that, always feel free to contact us. And that leads me nicely to, if you have any questions following my talk, or indeed any of the talks that have taken place today, please feel free to get in contact with us. I've only put my email address on the end of my slide, but I know the others may have done the same. Our clerks are all the same, so you've got Joe Gibson and Philip Spencer's email address at the end in any event. That ends the talk for today, so thank you to my fellow speakers, and thank you for taking the time to listen to all of our presentations, and we look forward to hearing from you with any questions that you may have.